MSW Media.
The rule of law is not just some lawyer's turn of phrase. It is the very foundation of our democracy. The essence of the rule of law is that like cases are treated alike. That there not be one rule for Democrats and another for Republicans, one rule for the powerful, another for the powerless, one rule for the rich and another for the poor, or different rules depending upon one's race or ethnicity. To serve as Attorney General at this critical time is a calling I am honored and eager to answer.
So now it's clean up on aisle 45 time. And for a long while yet, it is going to be clean up on aisle 45.
Hey, everybody. Welcome to episode 180 of Clean Up on Aisle 45. It's Wednesday, July 3rd, 2024. I'm Allison Gill.
And I'm Pete Strzok. We have a big show, in fact, a huge show. The Supreme Court has ruled that presidents enjoy some broad immunity, and we'll discuss how that could impact the state cases. Plus, the Fulton County Court pauses Misty Hampton's case, Mark Meadows battles over his White House records, and Judge Merchan modifies Trump's Manhattan gag order.
Also, on the good news side, Steve Bannon is officially in prison. Pete Navarro is sad about his conditions in jail, while January 6th criminals are recording podcasts from jail. Felix Sater, remember that guy? He's been hit with a $32 million judgment. Oh. Boom. And Rudy Giuliani has been disbarred in New York. But also Jim Jordan filed a terrible report on that. You remember the letter written by 51 former intelligence officials, Pete? He's mad still about that. But first, we have some new patrons to thank, including Stephen Potter, Allison Reagan, Debbie Sultan, Marita Woods, Sue, Raquel, Dane Lux, no shout out please, and James Baumgartner. So thank you to all the patrons who also showed up on our live Zoom happy hour last Friday. We had a great time. And we'll let you know when the next one is. And thanks again for supporting us and supporting independent media. If you want to join, head to patreon.com/aisle45pod. That's AISLE 45POD. And now on to the news of the week, the news of the decade, the news of the century, the news of the republic, honestly. Supreme Court has ruled, honestly, the presidents are kings. Here I want to read to you, Pete, Justice Sotomayor's dissent, because it's pointed. Today's decision to grant former presidents criminal immunity reshapes the institution of the presidency. It makes a mockery of the principle foundational to our Constitution and system of government that no man is above the law. Relying on little more than its own misguided wisdom about the need for bold and unhesitating action by the president, the court gives former President Trump all the immunity he asked for and more. Because our Constitution does not shield a former president from answering for criminal and treasonous acts, I dissent. And she also said, in fear of our democracy, I dissent. So hours after the Supreme Court issued its landmark ruling that he has some presidential immunity, and we'll discuss this a little bit more, our thoughts and stuff in a minute. But hours after that, Trump sought to have his conviction thrown out in his New York criminal hush money case, according to sources. Trump's lawyer said the hush money verdict would be tossed because the jury saw evidence during the trial they believe should have been protected by presidential immunity. And that's according to a letter to Judge Juan Merchan that was described by sources to ABC News. Now, usually you can use like privileged information on like First Amendment protected stuff as evidence in a trial, as long as it's not charged conduct. Like think of protected speech, for example. I can say the election was stolen. I have that right to say that. That is my First Amendment right. That is free speech. But I can't use that knowing lie to perpetuate fraud. The Supreme Court has now ruled that any official act that Trump took part in cannot be used as evidence for intent or motive, even if it's not charged. So they've gutted that rule for presidents, making them kings. So now Judges get to pick through all of Trump's behavior, whether it was charged or simply used as evidence, to determine whether or not it was an official act, and they'll toss it out if it was. So that's kind of what's happening here in this particular case and across all of the cases where he's charged. Now, the defense sought additional time to make their argument, a move that could delay Trump's sentencing, which is currently scheduled for July 11th. And by the way, we should add here, Pete, that the DA has not disagreed that sentencing should be delayed in favor of motion practice on this matter. And the judge hasn't denied or granted that yet. But since no party opposes it, even though the DA says we oppose his ideas, but we don't oppose a delay in the sentencing, I think we're going to see this July 11th sentencing put off.
Yeah, for sure. This is just minutes before we taped. This is the filing from the DA, a quote from the letter. Although we believe defendant's arguments to be without merit, we do not oppose his request for leave to file and his putative request to adjourn sentencing pending determination of his motion. We respectfully request a deadline of July 24, 2024, 2 weeks after defendant's requested deadline to file and serve a response. So I agree with you. I'd be shocked if Judge Merchan does not agree to this. And in anticipation of that the Manhattan DA in this case will file a response to whatever drivel Trump throws up there. They'll file their response on July 24th, and sentencing will be set at some point after that. So again, it'll still, upshot all this is it'll still all be decided, whatever decided looks like prior to the election. But it's certainly, I'd be shocked that, in my opinion, there's no way this is going to happen on July 11th.
Yeah, and I'm pretty sure that most of what occurred and what he was charged with are private acts. Which wouldn't be covered by immunity, but now, it has to be litigated. So we'll see what ends up happening.
Yeah. And the highlight of which you pointed out about the whole question of what the fact that not only are some acts immune, but just the fact of these immune acts, whether it's conversations with people in the government, that those may not be admitted into evidence, is one of the most extraordinarily disappointing aspects of the ruling, in my opinion. It's one of those things, too, that Judge Roberts said, well, that's not absolute. They're public statements, which, if they're made, can be offered into evidence. But he put all these caveats, and the most concern, it makes no sense to me. And the only thing that makes me feel better about it making no sense to me is a huge number of legal scholars look at this test about, admissibility of public statements, because, Trump's attorneys are already saying, well, courts have found that his Twitter feed was an official statement, and so you can't use it. The number of legal scholars with bona fide, JDs and teaching at law schools who are looking at this opinion and saying, I don't understand how this applies in practice, is stunning. And it just gives me, look, I know, we don't get into the federal charges, but there's no way in hell, even if Biden is reelected, in my opinion, I don't see the DC case going to trial for easily 1, if not 2 years before all this gets sorted out.
Yeah, I agree with that. There's so much to sort out. We will have some hearings over the summer, which I think are going to be beneficial to the public. We're not going to be able to get a verdict, but we'll have some hearings. But also, I wanted to talk a little bit about how this might impact Fulton County, Pete, because as we know, by nature, racketeering, RICO, has underlying overt acts that are uncharged acts. And what do you know about, what can you tell us about what of those uncharged acts might be evidence that falls under that umbrella of stuff that's not usable, that has to be tossed out because it's part of an official act?
Yeah, so much like they've already jumped on the Manhattan case to file a complaint, I'm sure that's coming in Georgia. This is from Professor Anthony Krice down in Georgia, and he says that 2 of the 8 manners and methods of an unlawful criminal enterprise under RICO could be substantially affected. And again, this is in the Georgia case, not the federal ones. And he goes on to say those 2 are a 5, solicitation of high-ranking United States Department of Justice officials, which specifically said members of the enterprise, including several of the defendants, corruptly solicited high-ranking United States Department of Justice officials to make false statements to government officials in Fulton County, Georgia, including the governor. the Speaker of the House of Representatives and the President pro tempore of the Senate. In one instance, Donald Trump stated to the acting United States Attorney General, quote, "Just say that the election was corrupt and leave the rest to me and the Republican congressman," unquote. And then 6, solicitation of the Vice President of the United States. Members of the enterprise, including several of the defendants, corruptly solicited the Vice President of the United States to violate the United States Constitution and federal law by unlawfully rejecting electoral college votes cast in Fulton County, Georgia, by the duly elected and qualified presidential electors from Georgia. Members of the enterprise also corruptly solicited the Vice President to reject votes cast by the duly elected and qualified presidential electors from several other states. But following that, Professor Kreis believes the most damning evidence against Trump is in a private capacity. And I do, some of that, there's already a lot of debate. And again, what makes this Supreme Court ruling so horrible is there's some question about Trump's interactions with the Vice President in the context of not certifying the vote. The Vice President was, in that capacity, the President of the Senate, right? Not the Vice President of the United States. So there's an argument
that's what got him out of some stuff on the speech or debate clause. Exactly.
But it's not clear. And so there's some allusion to that. Amy Coney Barrett dissented from the part about allowing testimony from immune acts that couldn't be admitted as evidence. And she goes on in her consenting opinion to state that it is very clear to her that the state electors, those are not a federal function. That's not an official act in any way. And she sees no reason that those cannot be tried. So again, it's a big, hot mess. And it is a mess that is not going to get cleaned up for years.
No, I agree. But as far as talking to the Department of Justice officials, the Supreme Court ruled that is absolutely immune. He should be able to, basically conspire with his DOJ to commit crimes, and that's considered an official act. So all that goes out, whether it's federal or state cases. So again, I think I have confidence that a lot of, more than half of all of the rest of his cases will be able to go forward, but not for a very long time because we have to litigate it. It's still appealable all the way up to the Supreme Court, et cetera, et cetera. So, we'll talk about more about that. But also, Pete, the Supreme Court is just blatantly wrong on this one. As conservative chief judge of the 11th Circuit, Judge Pryor made clear to Mark Meadows that he said the executive branch has zero role in the administration of elections. Roberts, though, this is the way he posited this. He said, well, and I'm paraphrasing, he said, well, Trump says he has oversight over elections because of the take care clause. That's the thing in Article 2 that says take care that the laws are faithfully executed. And the government says, no, not the state elections. The president has no role in something like the appointment of electors, and elections are run by the states. And Judge Pryor agrees, top of the 11th Circuit. Quote, the president, meanwhile, plays no direct role in the process, nor does he have the authority to control the state officials who do. And the framers, wary of cabal, intrigue, and corruption, specifically excluded from service as electors all those who from situation might be suspected of too great devotion to the president in office. And that's what the government contends. But Roberts says, determining who's right here and with respect to which conduct requires a close analysis of the indictment's extensive and interrelated allegations. No, it doesn't. You are making complicated something that is uncomplicated. And I think that is by design.
Yeah, and everybody's talking about this as a win for Trump and a win for the presidency, and clearly it is. But I think at the end of the day, is ultimately the biggest winner is the Supreme Court, because at the end of the day, all these determinations about whether something is in an official capacity, in a private capacity, whether it might be otherwise professional, and that determination of whether or not somebody can be subjected to prosecution, it's not the president who decides that. Ultimately, it's going to be the Supreme Court that decides that. So while everybody is looking at this creating an imperial presidency, it certainly heightens, irresponsibly so, the power within the presidency. But what it holds above that is that the Supreme Court are the ones who can decide whether or not something is prosecutable. So as much as it is doing for Donald Trump, for the presidency in general, it is doing even more for the courts. And if you look at that in the context of the rolling back of Jarchese, in conjunction of rolling back Loper Bright and all the, the administrative law abilities bribery, of the executive branch, Chevron, all of that, is enhancing the power of the courts. So, we're losing that a little bit. I mean, there was some focus when, it's throwing out saying, well, dang, Sam Alito can't even correctly spell, the term using nitrous oxide instead of the proper chemical. Gorsuch, sorry, not Alito.
Talking
never
about
mind.
nitrous.
We can't trust the experts. We have to trust the courts to use the wrong chemical compound in our Supreme Court judgment, which, of course, has now been corrected on the website, which is always
it wasn't a
spelling
error. It was
one-day
it was
retraction.
The wrong chemical. He was saying nitrous oxide when he meant nitrogen oxide. It's quite a bit different because factories aren't polluting with laughing gas going over state lines. At least not near me. It sounds fun.
I could use some laughing gas right now.
Right, exactly. All right, we're going to talk about a lot more. We have so much news to get to. Pete, I could talk to you about this, especially I could talk to you about this for like hours, especially the week of Independence Day, where we throw all this power. And the fact that the Supreme Court was like, well, we have to do it this way because it's a separation of powers issues, when they themselves are violating the separation of powers doctrine in the Constitution by giving outsized power to the judiciary, to they themselves, and to the executive, while stripping Congress of theirs. It's brazen. It's unconstitutional. And if Roe can be overturned, I think this can too. I'll be interested to see if King Biden does anything with his newfound powers. I tend to think not.
Of course he won't. Of course he won't, because Dems play by the rules, and they don't understand the rules.
But the rules just changed.
They're standing there with their saber, and they just handed out tanks and guns to everybody else on the playing field. But they're going to stick by their saber, and
the rules just changed.
It's not going to matter. It's not going to matter.
And I think it's a lot like how Democrats are against like money in politics, right? We're against money in politics, but we still take it because we have to, or otherwise the playing field wouldn't be even. I think the same should apply here, and I hope that they're talking about it at least behind closed doors, but we'll see.
Yeah. Keenan from Saturday Night Live, ain't nothing gonna happen. Nothing. Joe Biden could say, official act, I erase student loans. Come at me. It's not gonna happen. Not gonna happen. None of this.
Well, the Supreme Court already stopped that.
What's he gonna say? Well, I said, so what? I'm doing it. I know you said that, but I don't care. I'm doing it anyway.
It's not a crime, though.
It's not a crime. True. Nothing gonna happen. Nothing.
Yeah, we have to figure out what they can do first, if they do anything at all, and we'll see. But it doesn't matter. We still have to vote. It's up to us now. It's even more on our shoulders than it was before. We used to have the courts on our side, I feel, and now we do not. So, anyway, we have a lot more news to get to, but we have to take a quick break. Everybody, stick around. We'll be right back.
Hey, welcome back. We have more new patrons to thank, including Kathy Freeman, Courtney Guasden, Jennifer Twito, Karen Basor, Carrie Williamson, and Jocelyn Mortensen. Thank all of you so much. Thank you, especially in these times of a lot of turmoil in our nation, to supporting your support for this program, so we can bring you all of this news and talk about what it means to all of us in the path forward. So
yeah, and pretty soon we might be like pirate operators hiding radio, somewhere,
broadcasting from the Caymans, right? Posting from abroad.
We'll definitely need your support at that point.
Yes, yeah, 7 months at a minimum. We got 7 months to come up with a plan for Inauguration Day. So we're talking about Georgia, so let's stay down there in Fulton County. This is from Anna Bauer at Lawfare. Reporting that the Georgia Court of Appeals has granted Misty Hampton's request to pause trial proceedings against her, pending the outcome of an appeal that seeks to disqualify DA Fani Willis from prosecuting Trump and others in Fulton County. Hampton, you'll remember, is the former Coffee County election supervisor, is one of Trump's co-defendants in Fulton County. The Court of Appeals previously paused the proceedings of Trump and 8 other co-defendants while they litigate appeal over whether Fani Willis can stay on the case. Now, Hampton never joined that motion to disqualify Fani Willis, which means she's not a party to the appeal. But after the Court of Appeals stayed the cases of her co-defendants, she asked the court to put her case on pause too. And the appeals court granted that request. Makes Since to me, I have no notion. One, I was already concerned about how long it was going to take trial to get back on track in Fulton County. But now with the inevitable, matter of time, I guarantee before the end of the week, we'll probably see some new filing from Trump's attorneys down in Georgia, citing the Supreme Court ruling. I do not see the future path. I'm not saying it's not going to happen. I just don't. I could not. If you ask me, Pete, what's your guess as to when Fulton County will bring their case into actual trial? I have absolutely no idea.
No, me neither. I mean, after the Fani Willis thing is sorted out, they could bring the case against other defendants who aren't Trump while they work out what they can bring into evidence and charge Trump with. But it's this Supreme Court decision created such a huge mess. It's going to take a long time to untangle. And, I think because the appeals court granted Misty Hampton's request, even though she wasn't a party to the appeal, that kind of tells me that they aren't going to dismiss the appeal, which Fani Willis, the DA's office, asked them to in a motion. But we'll see. We'll get a ruling on that probably pretty soon, and we'll let you know when we do. Next up, from Kyle Cheney at Politico, Donald Trump's former chief of staff, Mark Meadows, has been quietly fighting a months-long battle to obtain thousands of records from his tenure in the White House, a bid to aid his defense against criminal charges in Georgia. Newly disclosed court filings show that Mark Meadows, with the backing of Georgia Judge Scott McAfee, has been pressing the National Archives and Special Counsel Jack Smith since May to turn over massive troves of phone records, emails, text messages, and other documents from his time as Trump's chief of staff in the White House. Quote, Mr. Meadows is entitled to these documents in preparation of his defense by law and as a matter of fundamental fairness and constitutional due process. That's what Meadows' attorney, John Moran, wrote to Jack Smith and the National Archivist Colleen Shogan in a previously unreported May 13th letter. This week, the battle spilled into Washington and the federal court amid resistance from the National Archives, which called Meadows' demands unreasonably vague, extensive in scope, and largely irrelevant to the racketeering charge he faces in Georgia. Now, Meadows contends that Fulton County DA Fani Willis never obtained these documents. Smith, who's also charged Trump with crimes, as we know, did rely on the documents, according to Meadows, and ultimately opted not to charge Meadows or label him a co-conspirator. Now, Meadows said that obtaining his White House records will help disprove claims that he was conspiring to overturn the 2020 election results and was rather an active participant in the transition from Trump to Joe Biden, as well as focused on his other government duties. Which I guess
running around in a car trying to track down the binder that he'd given to John treason. Solomon with hours before the inauguration. Yeah, anyway.
Burning papers in his office after meeting with Scott Perry.
Yes. Active participant in the transition.
Totally. Yeah.
Wife complaining about the smell of smoke in his clothes because of everything was burning in his fireplace. Right.
Mm-hmm. Now, Meadows' lawyer indicated in one filing he had informal inquiries with both the National Archives and Jack Smith's team, and that they will not produce those records without a court order. So that's what's going on there. But what is he looking for?
Yeah, it's exhaustive, right? So among the records that he's seeking include virtually every email, text, schedule, and written file he produced as White House chief of staff, including on matters related to the government's COVID-19 response, work on a Middle East treaty, the withdrawal of troops from Afghanistan, and other national security matters. Also, his communications with Joe Biden's transition team after the November election, including notes, quote, related to instructions to brief President-elect Biden and the Biden transition team members within secured settings, unquote. Air Force One's flight manifest during his tenure as chief of staff, and a breakdown of flight expenses. Trump and then Vice President Mike Pence's internal schedules from Election Day to Biden's inauguration, months of White House visitor logs, not that they ever published those like every other White House in recent memory, Meadows calls to and from Air Force One, all email and text communications among Meadows and top White House aides like Deputy Chiefs of Staff Chris Liddell and Tony Ornato, Executive Assistant Cassidy Hutchinson, Assistant Eliza Thurston, and Trump Assistant Molly Michael. Now, the National Archives contended the broad swaths of records could not be reasonably connected to his criminal defense in Georgia, since many of them significantly predate the alleged crime. I tend to agree. I am all for, I think there's a reasonable argument that some of these things, particularly at and around the inauguration of the period between the election and the inauguration, there might be material in there that you're entitled to put up your best defense. And so I think there's some merit. But to go back and talk about, months and months of flight expenses on Air Force One, really? Why? Just to show you were? Some of this makes no sense, and it seems like a fishing expedition. And I would envision we land somewhere that you can have some, but not all of this stuff. But we'll see.
Yeah, and discovery rules generally are anything that the prosecutorial team has. And I mean, I suppose you could ask Jack Smith for what he has, but to go after the archives for stuff that nobody has, it seems like that's not part of discovery. That's not. I don't think the National Archives is part of the prosecutorial team. I know that Donald Trump is contending down in Mar-a-Lago that the prosecutorial team includes every single federal agency ever and anyone who's ever worked for the government in the past, going back to the 1800s. But I don't know that they're necessarily going to grant this, at least not all the way up to the Supreme Court level. But we'll see. We'll keep an eye on it for you. All right, we have more news to get to, but we have to take another quick break. So everybody stick around. We'll be right back. Hey, everybody. Welcome back. We have more new patrons to thank, including Gail Fulbeck, Joanne Vining, Linda Miller, Jesse D. Myers, Betsy Nolan, Katie Ellison, and Carol Anderson. Thank you. Thank you so much for supporting independent media and supporting this show, since we're going to have to travel underground and report from caves, if we don't all get out and vote for Joe Biden. So thank you very, very much. And, even if we don't have to, if Joe Biden wins the election, we don't have to broadcast from caves. We still have a lot of really important expenses to pay. So thank you for supporting us. Let's head back to New York, because Justice Juan Merchan has modified Donald Trump's gag order. You'll recall last week, we reported that Alvin Bragg had asked Justice Merchan to keep the gag order in place, at least most of it, right, until sentencing, which now has been delayed, so it's going to go on even longer. And this is in the face of Trump filing to lift the gag order in its entirety. Now, the DA argued that it was still important to bar Trump from speaking about prosecutors other than Alvin Bragg himself, their families, court staff other than the judge himself and their families, as well as jurors. But Alvin Bragg said he no longer needs a gag order for comments from Trump about the witnesses because they've already testified. So any public comments about witnesses like Stormy Daniels or Michael Cohen will no longer chill their testimony, but they are still subject to criminal statutes. Like, he can't defame them and he can't make, overt threats or whatever. So they're still subject to those kinds of crimes. He's not a president right now, so they aren't official acts. But that's just always in the back of my head now since this came down from the Supreme Court. But since then, we got Judge Merchan's decision, and he did lift the gag order as to the witnesses, but he also lifted it as to the jurors or the jury in general, but said that the jurors' identities and information, personal information, must still be kept private. That is still sacrosanct. That is still to protect their safety. And so I thought that was a reasonable ask from DA Bragg, and I think it's a reasonable. I probably still would have kept the gag order on for the jurors, but I don't think it's wholly unreasonable what Judge Merchan did in further narrowly limiting this gag order.
Yeah, I think that's right. And I mean, the reality is that if it was a quiet, otherwise empty summer, Trump might be going after, Stormy Daniels or Michael Cohen right now. But there's so much going on that even with this lifted, he might. I think Stormy Daniels is giving an interview to Rachel Maddow next Monday, I think, or soon. And so it might prompt, there's a little monkey in Donald Trump's brain that has a pair of cymbals that just bangs out whatever the most interesting thing at that moment is in front of him. And there's so many interesting things in front of him right now. Luckily for Michael Cohen and Stormy Daniels, I think they're, kind of far down on the list right now. But it doesn't strike me as unreasonable. I mean, being able to talk about the jury broadly is reasonable. Maintaining their privacy and their identities, which he did, is absolutely the right call. But, I think this all is going to hinge on what happens with, their attempt to throw out the conviction up in New York based on the Supreme Court decision.
Yeah. Agreed.
So, yeah. Well, let's go to Penn Station, hop on the Acela, which hopefully doesn't break down, and go to Washington, D.C., because in Congress, Jim Jordan is still harping on the letter written 4 years ago by 51 former intelligence officials regarding the credibility of Hunter Biden's laptop. And of course, Jim Jordan is blaming the CIA. And we're in July of 2024, and Jim Jordan is still trying to find the damn Lindbergh kidnappers. It is just one of these, he can't let go. And it's absurd. And this is thoughts from Brian Greer, who was a former chief of staff to the general counsel at the CIA. And he says, this Jim Jordan report on the letter from the former intel officers is one of the dumber things I've ever read. It doesn't appear to even have a good theory about what the CIA did wrong, but it assumes that randomly quoting some internal emails will give Fox News what it needs. And that's actually probably right. Greer continues, first, it suggests that the CIA should have stopped the letter even though it didn't contain classified information. Well, that would violate the First Amendment rights of these individuals. If it doesn't contain classified information, the CIA cannot stop its publication. See the Constitution. Second, it suggests it didn't stop the Supreme Court, but maybe it'll stop Jim Jordan, right? Mm-hmm. Second, it suggests that the CIA should have vetted the letter. This is not the CIA's job in pre-publication review. Its only job is to remove classified information. If the information is not classified, whether it's accurate or not is irrelevant. The PRB is not the truth police. Third, it suggests that the letter was given special treatment due to the fact that it was completed in 6 hours. I'm a nobody, and I've had much longer articles approved by the PRB under similar timeframes. I've had one longer piece approved in 3.5 hours and another in 6.5 hours. To be sure, the PRB can take much longer than that, and this is Pete's interjection editorially, and in fact, the FBI's pre-pub review is abysmally slow, horrible. Simple editorial can take a week or longer, but setting that aside, Greer continues, it's gotten much faster in recent years, and I regularly get submissions approved within 24 hours. The fact that Morell was a former DDCIA, Deputy Director of the CIA, absolutely helped, but they'd move quickly with him regardless of the content. Fourth, it suggests it was somehow wrong that senior officials were aware of the letter. Huh? Their awareness is not improper unless it was for the purpose of interfering with the review process. The report's authors are actually mad that these officials did not interfere. Fifth, it suggests that it was wrong for CIA's PRB to coordinate the letter with their ODNI counterparts. Again, huh? If CIA PRB thought the ODNI, and again, this is Office of the Director of National Intelligence, the rest of the intelligence community, if CIA PRB thought the ODNI had an equity in the letter, it was absolutely proper for them to refer it to them. That's standard practice. This is silly. The one legitimate question raised by the report is that some of the signatories were on contracts with the CIA at the time. That's a fair question. There's a fair question of whether they should be held to a higher standard. But as the report acknowledges, they are not subject to the same Hatch Act restrictions as employees. Even here, the report distorts. It rails about these contractors receiving quote-unquote taxpayer dollars, but it doesn't mention that 4 of the 6 were on no-fee contracts. They were working for free, and their contractor status was not publicly known. He concludes, Jim Jordan can criticize the letter all he wants. That's fair game, and it should be debated. And the signatories can defend themselves. But this report is a pretty pathetic attempt to blame the CIA for not preventing the publication of a letter that no one believes was classified. I completely agree with Brian. I think this is a silly attempt to sort of gin up some scandal or news or sound bites for Jim Jordan. I think it will probably work. I think most of the country does not care, except to the extent it just feeds the sort of like ask an average MAGA or undecided voter, what was this whole thing with Trump and Russia? And they respond to either, oh, it was a complete hoax, or, oh, I don't know. It seems like there was all kinds of like shifty stuff going on. So it just undermines the fact that, yes, in fact, people like Ron Johnson and Chuck Grassley were receiving information from what have now been designated as active agents of the government of Russia. It just throws mud into that entire series of events in history. I also agree with Brian that when I found out that some of those folks who signed it were on contract with the CIA, it made me think, you know what, I probably would have been better if you're going to characterize yourself as retired, then don't sign it if you're still on contract, because I think that gets in the way of sort of the power of saying we're retired. But that's a nit, and it's, as Brian said, it's a reasonable, observation and a question. But in general, there's nothing illegal about this letter. There is nothing inappropriate about what the CIA did and its handling of it. And it's a tempest in a teapot.
Well, that's what they have, right? They have like 4 things that they are on about over and over and over again. I think of Jim Comer and his, China dealings with emails from aliases, and we find out that from Roger Sullenberger, who got a open records request, that Jim Comer sent somewhere between 1,200 and 2,700 emails using an alias doing business with China while he was at the Kentucky Board of Agriculture. Okay. And then he's like all these loans back and forth, with the $200,000 to $40,000 check. And then we have Jim Comer doing land swaps with his brother with money missing. Right. So it's, it's every accusation is a confession, but they hang on these one single things for years and years. They still bring up Benghazi. They still bring up the emails. It's all they have. Now we have a million scandals we can talk about, and it's hard to stay and focus on just 1 or 2 because there are so many. And that is the point of having that many scandals, is because it's hard to focus on just 1 or 2. So that's unfortunately where we are. And it works on the opposite too, right? Like Joe Biden has done 100 million awesome things. So it's really hard to just focus in on one and pound that until the election. But I think focusing on democracy, the corrupt Supreme Court, and the fact that Donald Trump would be king, I think are 3 real good ones that we should focus on between now and the election. And now, Pete, a blast from the past, a blast from your past. Let's talk about our good friend Felix Sater.
Allison, would you do me a favor? Because you're probably one of the 20 people outside of the United States government who actually remembers who Felix Sater is. Can you give a little thumbnail about Felix for our dear listeners?
Here's my always favorite thumbnail. He's the guy who got arrested for stabbing a dude in the eye with the broken end of a margarita glass. That is how I always remember Felix Sater. You can talk a little bit more about his touches with the Trump campaign in Russia, but there was a civil suit against him for money laundering, and he is now in the hole. $32 million was the judgment against him from the jury verdict. For money laundering. And this all has to do with Russia and the Trump campaign. Share your past stories of one Felix Sater.
So look, there's a lot there. And there's a lot there that's in the public domain. He was formerly the managing director of an entity called the Bayrock Group, which was a real estate conglomerate in New York City. He's an advisor to the Trump organization, notably going back to the late 90s, not even the aughts. 1998, he pled guilty in some stock fraud scheme that was connected to the Russian mafia. Allegedly, there might have been the beginning of a relationship with the FBI at that time. But very importantly, in 2016, he worked with Michael Cohen to broker a deal to build Trump Tower Moscow. Remember when Trump was sitting there simultaneously with them doing this, Trump on the campaign trail saying, my campaign I have nothing to do with Russia. Absolutely no financial dealings. Michael Cohen was working with Felix Sater to try and set up that Trump Tower Moscow deal. And Sater told Cohen, I can help Trump's election using my Russian contacts. So that's Felix Sater. And right. He clearly is... He is one of these people who has parlayed his connections in both the licit and illicit realms of businessmen, organized criminals, political players, intelligence players to advance his own interests. And there's no doubt in my mind that his proven connections, one, to Russian organized crime, and his alleged connections, his speculated in the media connections to Russian government and intelligence officials, it is a reasonable thing for anyone to believe that those exist. And his proximity to the Trump campaign, again, there may not have been criminal time for Felix Sater, but the prospect of tens of millions of dollars in fines strikes me as at least some measure of karma.
One of my favorite things about being friends with Pete Strzok is that I know you know a ton about Felix Sater that you can't talk about. And that's frustrating, but also kind of cool. So anyway, we'll just leave it at that. But, you know, like you said, all of the things you talked about are publicly known about good old Margarita wine stem eye stabby guy. But yeah, just one of those kind of ancillary characters in the mob movie that helps launder Russian money through Trump properties and shit like that. Fascinating. We talked about him at length, ad nauseum, on the Mueller, She Wrote podcast. And just this week, I was pleased to learn that he is $32 million poorer. So thanks for that, Pete. Thanks for the information. And we actually still have the next block coming up. The news gets better as this show goes on, kind of how Biden got better as the debate went on. It started out like just awful, and we're going to have some really good news here at the end. So I'm excited for it, but we have to take one more quick break. Stick around. We'll be right back.
Hey, welcome back. Our final list of new patrons includes Me IF, Christina Hoffman, Gina, Sherry O'Connor, Terry Klotz, James Leach, and Kidding Me? Thank all of you so much. Thank you for your support of the program. Is it Mel F? Yeah, you're right. That's not an I. That's my apologies. That is Mel F. Thank all of you so much for your support of the program, for being part of the team, for letting us put this together every week. Truly, truly honored to have you as patrons. So thank you. And with that, let's head to DC jail with this piece from Talking Points Memo. Some of the people who were convicted for their actions during the January 6th attack on the U.S. Capitol have insisted the unit where they were held before sentencing in the Washington, D.C. jail is an abusive, quote-unquote, gulag. It's also ground zero for a burgeoning media empire that appears to violate jail policy and features broadcasts starring people who were convicted for their role in storming the Capitol as former President Trump's loss in the 2020 election was being certified. A pair.
I'm interested to see how they react to the immunity thing, because none of them get immunity.
No, but I mean, there have been some. I mean, the filings are coming in for some of the folks that were like, this is not so much the immunity case as the 1512C, the Fisher decision. Those are rolling in. But, going to the conditions in D.C. jail, a pair of the so-called J6ers have hosted a DC Gulag podcast, that's their name for it,
God,
where they have interviewed their fellow inmates while promoting various aspects of their agenda, including false conspiracy theories about the 2020 vote and the idea they are waging a noble political struggle. Despite the obvious issues with these claims, hero worship of the people who attacked the Capitol has become a persistent feature of MAGA politics. And thanks to an unusual setup, some of the prisoners themselves are embracing that spotlight. Now, inmates are generally restricted from accessing the internet and communicating with the outside world, a situation that has raised questions for years about how to properly balance security concerns and freedom of speech. In their premiere episode, which was released earlier this month and filmed last year, one of the podcast hosts, Jonathan Mellis, now an inmate at FCI Ashland in Kentucky, perhaps we can look at the canteen list for FCI Ashland at the next bonus episode in a few days, explained how they were able to get their unique show online. Quote, "What I think the establishment didn't count on is us being able to have laptops to view our discovery that accidentally have a camera attached to it so that we can actually get to know some of us while we're in here," unquote, Mellis explained. Well, thank you. Thank you, Jonathan. I would hope that to the extent that this violates prison policy, perhaps the prison personnel can take a look and decide whether or not this, it's not like you're broadcasting anonymously. So hopefully if there is a violation of rules, that can be fixed, but who knows?
I think what's funny is that they're using their access to laptops to do podcasts. At least Manafort was foldering, like at least he was hiding emails. Oh, these guys. Bless. All right. Next up, Pete Navarro has filed a second unopposed motion for extension of time to file appellant's principal brief and appendix. He He respectfully moves the court for an additional 14 days of time to file his principal brief and appendix pursuant to the federal rules, etc. The brief is currently due June 27th. This was due June 27th, meaning the extension would result in a new deadline of July 11th. The undersigned has conferred, that's Stanley Woodward, Pete Navarro's, crackerjack lawyer. The undersigned has conferred with counsel for the Appellee United States of America, who doesn't oppose the extension. Good cause exists to grant it, although it is being filed within 7 days before the brief is due. So it's last minute, sorry, but the government's cool with it. Second, on yesterday, which was June 23rd, when, because this was filed on June 24th, the lawyer attempted to visit with Navarro, but was denied a legal visit. Since the day of his self-surrender, counsel for appellant has been advised that legal visits could only occur on weekends due to staffing shortages at Federal Correction Institution, Miami. Indeed, representatives of the facility advised in writing April 4th that visits by counsel were permitted only on Saturdays and Sundays. Yesterday, however, counsel was advised by the lieutenant, an officer in command, that legal visits are permitted only during weekdays. Although permitted a social visit, counsel was unable to review with appellant the draft of his principal brief. So we need 7 more days. And so for the reasons stated herein, Navarro respectfully requests this motion be granted. I'm sure it will be granted, but he's sad that he can only visit on weekends. Navarro, if you'll remember, Matt Gaetz tried to go visit Pete Navarro and was denied. And then they made a big thing of it. And now Jim Comer and Jim Jordan are going to have a hearing and they're going to grill the director of the Bureau of Prisons on their politicized visitation rules or some such garbage while these guys are in jail. And we're not going to hear the end of it, especially when Bannon's in there. So, but let's talk about Bannon.
Yeah, well, since we last spoke, Steve Bannon had filed one last appeal to the Supreme Court to delay his prison sentence pending his appeal, and the Supreme Court said no. And as of Monday, July 1st, Steve Bannon is known as 05635-509, and as we tape, is on day 2 of his time as a guest at the Danbury Federal Correctional Institute. So he was there. Interesting, this is very interesting. One, I expected Marjorie Taylor Greene showed up for a little ad hoc press conference before he turned himself in. Anarchy Princess, who's, I don't remember her true name, that's her Twitter handle, was there doing fine work in the background, holding up a sign. Yeah. What was really interesting to me, though, and again, wasn't picked up, that in the background of that and supported by subsequent tweets, the people who drove with him to his turn-in were Bernie Kerik and Eric Prince. And I saw Kerik in the background, but like Eric Prince involved in all this just makes me, again, one of those reasons to be concerned in a second Trump presidency. I'm less concerned about what he tries to, he's going to have a difficult time, quote unquote, weaponizing federal law enforcement, but he sure as heck could turn to a bunch of, mercenary contractors to do quasi extrajudicial things all around the United States with far less opposition. And since it's an official act, who's going to stop him, right? But it was an odd, Kerik and Prince in particular did not sit well with me seeing them there at his turn-in.
No, right. Yeah, because I feel like he's going to gather up the Oath Keepers and the Proud Boys and the Boogaloos and the 3%ers and put together some mercenary comitatus or some shit, and it's all going to be very, very bad, because that's what Eric Prince does, by the way. That's what he does. Puts together mercenary armies. All right, one last thing I'd like to read to you for today. Wherefore, it is ordered that the motion by the Attorney Grievance Committee for the First Judicial Department to confirm the referee's report and recommendation pursuant to 600.8 AT4 and 22 NYCRR 1248B2 is granted, and respondent Rudolph W. Giuliani, admitted as Rudolph William Giuliani, is disbarred from the practice of law effective immediately and until further order of this court, and his name stricken from the roll of attorneys and counselors at law in the state of New York. And it's further ordered that the cross motion of Rudy Giuliani to disarm the referee's report and recommendation is denied. And it's further ordered that effective immediately, pursuant to judiciary law, the respondent, Giuliani, is commanded to desist and refrain from 1, practicing law in any form, either as a principal agent, clerk, or employee. 2, appearing as an attorney or counselor at law before any court, judge, justice, board, commission, or other public authority. 3, giving to another an opinion as to the law or its application or any advice in relation thereto. And 4, holding himself out in any way as an attorney and counselor at law. And it's further ordered that Respondent Rudy Giuliani shall comply with the rules governing the conduct of disbarred attorneys, which are made part hereof. And it is further ordered that if Rudy Giuliani has been issued a secure pass by the Office of the Court Administration, it shall be returned forthwith.
Nice.
You're welcome.
Great.
You're welcome.
Amazing. Now do Jeff Clark, John Eastman, Sidney Powell. The list goes on and on. I know they're underway, but much like Trump,
Sidney Powell's not underway.
No, that's true. Thanks, Texas.
I numbered 2 paragraphs wrong or something.
But much like the judicial process, the judicial ethics process, and the various bar grind, certainly slowly. We'll see if they grind fine. But at least Rudy, America's mayor, has landed where, frankly, he deserves to be, disbarred, in bankruptcy court, hiding assets probably, and just ending his life on a note that he'll forever be remembered for in the history books. But can't practice in New York.
You can't even advise on the law. That'll be interesting. I wonder if he has to say, okay, now I'm not giving you any legal advice here, like with everything that he ever says. Would be pretty funny. All right, that's the show. We march on. And again, thank you to our patrons for helping us do that. I know these are pretty dim times, and it's understandable if you're frustrated, depressed, anxious, and worried. We're there with you, but we all have each other, and we'll hold you up. We just got to get out there and vote, do our part. It's up to us. It's always been up to us, but now it's extra up to us. Like I was like, well, it's always up to us, right? We'll have a little leg up from the courts, little leg up from laws. We kind of don't really have that anymore. So it is up to us, and I know we can do it. Pete, do you have any final thoughts before we get out of here today?
No, look, I mean, grieve however you want to grieve, mope, be upset, but do that. And then, like any good grieving process, get your head in the game. I mean, there's an appropriate amount of time to be angry, to sit there and think about like all the implications of this. But at the end of the day, I think you're going to land on the truth that this is a horrible decision, on a ending of a set of horrible decisions from the Supreme Court, which really places our democracy at peril. And the one thing that you can do to ensure that it stays safe is to get every single person energized to the fact that this coming July 4th, tomorrow, as you're listening to it, may be the last Independence Day as you have come to enjoy it in your lifetime if we don't reelect Joe Biden. So get your head right. Do what you got to do to get past this. I'm certainly woke up in a foul mood this morning, but get your head right and get in the game, because all of us and every single person have got to be there. And so with that, wish everybody a truly great 4th of July. Ponder with your beer and cookout or adult beverage or mocktail, whatever you drink, what this nation means and what the original 4th of July meant, and dedicate yourself to making sure we hold on to that, because it's that serious. So we'll see you on the bonus.
My advice is postcarding to voters in swing states. There are, blue wave postcards. There's tons. You get to get creative. And I know that if you're down, it will make you feel better to do that. It's simple. It's inexpensive. It's something most people are able to do. So that would be my one recommendation, because I can't tell you how much better it makes me feel. It's exponentially more than you would think, to just take a little bit of a part in that. So that's my recommendation. Everybody will see you at the bonus. Until then, I've been Allison Gill.
And I'm Pete Struck.
Cleanup on Aisle 45 is written, researched, and produced by Allison Gill, with editing by Molly Hockey. Our art and logo design are by Joelle Reeder and Moxie Design Studios, and our music is composed and performed by Adam Orr. Cleanup on Aisle 45 is a proud member of the MSW Media Network, a collection of creator-owned podcasts dedicated to news, politics, and justice. For more information, visit mswmedia.com. MSW Media.